All right.
All right. Good evening, ladies and gentlemen, and thank you for joining Keith Miles and myself, Shannon Wilson, for our monthly workshop that is sponsored by ICABA, International Career and Business Alliance. It is always our pleasure to come before you and give you some tidbits of information regarding estate planning. Our monthly sessions are not meant to create any sort of attorney-client relationship. They are purely informational from a standpoint of this is what everyone should know about whatever our topic for the month is. And so we always come on the third Tuesday of every month at 7:00 p.m. and present a myriad of information. We have covered topics like wills, like what we need to know about planning for our families in the future. We've talked about powers of attorney. We've talked about healthcare directives and what that looks like. And now this month we are covering the topic of heirs property. Just in the news in the last couple of weeks, there's been several articles and stories about property being taken from families that had been in the family for generations. And so Keith and I decided that we were going to alter slightly our original schedule and cover this topic now because it is so incredibly timely. So just by way of introduction, we always want to start off by thanking ICABA, that is our sponsor. Again, I encourage everyone to go to the ICABA World Community, that's ICABA World Community. Go to their website, check it out. They have fantastic mastermind groups. The estate planning mastermind group is the one that Keith and I manage. There are groups on any topic that you could think of. There's one on estate planning. There's one on financial resources. There's another one on entrepreneurship. There's several. And so check out the ICABA World Community for a vast network of information. So we have this workshop, like I said, the third Tuesday of every month. Next month, we're going to be talking about some special needs planning considerations. In May, we're going to be talking about how you can use insurance as an estate planning tool. And then in June, we're going to do kind of like a year in review of all of the topics that we've talked about. And we're going to highlight the high points on each one of those discussions. You can also, if you missed them, check out the replays, right, Keith? They are all in that ICABA mastermind group. So I encourage you to go check those out. Let your friends, family, colleagues know about them. It's fantastic information that everyone needs to know. None of the information we bring is targeted to a specific group of people or audience because it is information that applies to every adult. So check it out, and without any further delay, so that we can make the best use of your time this evening, we are going to talk to you tonight about heir property. Heir meaning H-E-I-R, not A-I-R. So many times people think about that, and when I look at the picture I have here with all of this air up here in the sky, but then you look down under it and there's lots and lots of land and lots of property. And so many times people lose that property that may have been in the family for 2, 3, 4 generations because they did not properly plan for what to do with that property. So let's talk about heir property and what it is and what all is involved. And Keith and I do a back and forth on the information, so you will be hearing from both of us sometimes simultaneously on the information. So the first thing we have to talk about is, what is heirs property? What is it? I'm a definition person. I love Webster's. I love Black's Law Dictionary. I love any sort of dictionary that gives me a definition. But heir property is essentially a home or property, land, that's jointly owned by the descendants of a deceased person. That means by the heirs of somebody who has passed away, whose estate was never probated according to the law. Or sometimes it was probated, but there may have been something that didn't completely go through with that. So that is what is created when there's heirs property. Essentially, it's property that's passed down from generation to generation, creating multiple ownership of the same piece of land. Grandma had it, she passed it to 4 children who passed it to 20 children. We have heir property now because the deed has 20 people's names on it, or the deed has 1 person's name on it, or 2 people, both of whom are deceased and their property hasn't been through the probate process.
And Shannon stressed that most of the time you're going to have issues. You mentioned that deed with 1 person's name on it, and people are usually thinking that's a satisfactory action. Okay, all I had to do is get the verbal, this goes to you. And they don't necessarily feel the need to do any formal legal step of going to the courthouse, doing some land records and showing a chain of title. So a lot of times they'll just pay the property taxes and say, well, I'm paying the property taxes. I have the right, I'm staying in the place. So surely it's mine. And that's not how we as lawyers, we look at the title. We look at want to see a line from one person all the way through to the next. And if you haven't taken that probate action to actually go through and have the court say, recognize you as an heir, then you are technically one of many that's undefined right now. So even though you're walking back and forth through that property and living there, someone, and we'll talk about later, may come along and challenge your right to own that property.
Yeah, so when is it created? When the will, or the last will and testament, leaves property to multiple beneficiaries, or when there's not a will and the property passes through what are called the laws of intestacy. And that means a person died intestate or without a will, and now there's a chart, and every state has their chart. Most of them are quite similar, but every state has their chart that indicates when a person dies without a will, who gets what does that line look like? And so that is when your property is created.
And I just want to, with the intestate, I want to make sure people understand, like Shannon said, that's a statutory thing. So sometimes people think, well, that child is estranged, or we know mom or dad didn't want him or her to get it. The statute does not care. If you die without that will, they have an interest by that statute. So if the only way to get out of that statute, the only way to make sure that the people you want to get something is to have a will. If you leave it in without the will, the state will make a plan for you. And then that's what also happens when Shannon says, if that person then passes away after they got it from the first person, then their statute says where that goes. So you keep having this chain of expanding people.
Yeah, the statute, which is the law that says what happens, dictates. And so many times, especially in some communities, people may have family or friends that they want to leave something to, but the law would say that family member is not entitled to it because they're not in the correct order when it comes to the chart. Or no, that person's not related at all. So unless you have something in writing that says they are entitled to it, they will never get it. So what does all of that mean? Every day, like all over the country, every day, owners of real property pass away without leaving a will, or they pass away without engaging in strategic and well-informed estate planning. When we say strategic and well-informed, you have to be informed and you have to know what it is all about. It's kind of like playing a game. If you don't know the rules, you're going to lose. And so there's a strategy to planning your estate that doesn't just look at who you have right here, right now, right next to you, as far as your family goes. But strategic estate planning looks down the line generations from now and sees what happens, what could potentially happen. We know, the 3 and 4 generations from now are not defined. They're not even here. But the law says this is what happens. And so you have to be strategic about estate planning. And how does that relate to heirs property? Essentially, new owners, and when I say new owners, that means the people who are now living, whose names were not on that deed, or maybe a spouse was on the deed. So the new owners are tenants in common. In common means a certain thing when it comes legally. There's language in the law is everything. And I know there's probably lots of non-attorneys on this call who would agree with me. I agree, and I am an attorney. Language is everything, and you can have one word that throws the whole thing off. And so the language in the deed says, well, the language for the lack of the deed says, now you all are tenants in common. That means you all have a common interest in that property. A common interest in that property. That means, and we're going to go through all of these things, what that looks like when it comes to if you are one of those tenants in common.
Before we go through this, I just want to make sure, because like I said, some people here aren't lawyers, so they're not familiar. We really have kind of three different, there's tenants in common, joint tenants with right of survivorship, and then some states have tenancy by the entirety. With the joint tenants with right of survivorship and tenants by the entirety, those forms of ownership have right of survivorship. So whoever passes away, their interest by operation of law automatically goes to the remaining people. So if you have 4 people that start and they keep dying off, whoever finishes last has 100%. So that's basically what the other form of ownership is. With tenants in common, that stays with the person. So if you give 4 people ownership tenants in common, when that one person passes, that 25% interest will pass down through their will, or if they die without a will, the intestacy. So that's the part that we'll start talking about, what's happening when you say tenants in common versus other methods.
Yeah. So what does that mean? That means that each and every one of those tenants in common have to agree before any major decisions about the property can be implemented. Every one of them. So if there are 40 people, all of them, each of them have a right to a say-so in any decision-making process.
And I want, before we go further, like people think, say you had a corporation, if I own 70% of the corporation, I could just dominate that because I could make all the decisions, I own all the shares that have power to vote. It's not the same as Shannon said, anyone who has an interest in the tenants in common can make a decision. So that is a completely different mindset to understand when you have a piece of real estate versus say a corporation. So it causes a lot of different problems when that any individual who has that interest can basically outweigh some other people in decision making.
Yeah, it's really can be very quite splintering. The second one, every single one of them, again, if there are 2, each of them, if there are 40, each of them may transfer their interest in the property to another heir or to an outsider. This is where most of the problems come up, when they transfer that interest to an outsider. Many times now we're finding that that outsider is usually a corporation that comes in, and now this corporate entity or an individual who's trying to buy up a whole lot of property in the area, they end up with that portion of the property. And since each person can transfer their interest, they hone in on that.
And this is important too, because a lot of this, especially in our community, is a lot of verbal, I want this to happen, or this is the plan of what I want you guys to have this together. But all it takes is one person to not follow through. And they have the right to, no one else can veto it. They can just do it on their own. So Shannon said this is a very important point. They can be to another family member, or they can go outside the family and completely disrupt the entire scheme that was originally planned.
Yeah. Each of them have an equal right to full use and enjoyment of the property. So many times I know you've heard, well, my cousin so-and-so is living there, so no one else can. Well, yes, each individual has a right to full use and enjoyment. That means they can live on it, they can build on it, they can add on it, they can plant those crops, they can use it for monetary gain. They can do what any of them can do, what all of them can do.
Family dynamics, someone's personality might be stronger and they think, well, I'm the oldest, or I'm usually here, I was taking care of mama before she passed and I have the right to be here. Doesn't matter. Everyone has the full right to use. So that can cause some family strain as well.
Yeah, and it's funny you said that, because they say I have a right to be here. Well, so do all of the rest of them. And that's where the strain comes in, because people think that is not the case, but it absolutely is. Each are responsible for the taxes and expenses related to the property. That's another one where, one person thinks that just because they're paying the taxes or the expenses on the property, that they have more of a right to be there or a right to the use and enjoyment of the property than others. And that could not be further from the truth. That person that has no idea how much the taxes are, never cared about how the taxes are paid, they have just as much of a right to and a responsibility to pay them as everyone else does.
And then the last one, each may have the property partitions or split, and this can happen either by sale or they can do it by gift. So it's a bunch of different methods where you can start having the original intention of the joint ownership changed by one person's actions.
Right. And a partition means the property is split up into subparcels, parcels, and so they can sell out their subparcel if they want to.
Okay. I saw a hand raised. If you can use the chat, it'll be easier if you could type the question in the chat and then we'll read it out loud.
Yeah, that'd be great.
We'll try to answer.
So what's wrong with all of that, creating the property that way, and the fact that some families, some entities have really, really large plots of land and some have smaller plots of land, but you know, land is land. What we know is there is not going to be any more land on this green earth that we have. You know, if you look around, at least here in the metro Atlanta area, everything's building and everything's building up because the land itself is slowly dwindling. So we know that once you let go of that property, it's really, really tragically difficult, if not impossible in some situations, to get it back. So what's wrong with heir property is the fact that we lose land that we are entitled to. We lose land that connects us to our family history. We use land that we could be using as a wealth building mechanism. And that messes up the entire scheme of things. There goes legacy building. And so family disputes, I'm just going to go through these in a little bit of order. We'll probably skip around a little bit, but family disputes and splintering, because splintering is where the property splits off or the family splits off. You know, people pick sides and people know, you know, that was grandma's, I was grandma's favorite. Grandma told me that she was going to give it to me. And grandma was having that same conversation with all 20 of her grandkids. So they all thought that they were getting the same property. And realistically, if grandma did not leave a will, and they may have. And so it causes splintering. People disagree on things all of the time. And land and property is not at all immune from those disagreements.
We have a question here, Shannon.
Yep.
The question is, if there is land owned by multiple heirs, for example, 10 heirs, but only one is paying the taxes, even though all heirs and owners are responsible, if they're not being responsible, what would be necessary or what could be done by the one person handling all the responsibility to gain ownership in full?
Yeah, so we're going to talk a little bit about that. That's a great question, because while they are all responsible for paying the taxes or, you know, the expenses of the property, if they are not all doing so responsibly, now that one person that is covering them, they have leverage that they can potentially use on the other ones. However, it doesn't give them any more rights than those who are not paying. So they can use it as leverage to get the others to sell their portion to them so that they can have all of it, but they don't have any more rights than the others. I think that answered the question. If not, feel free to type in further in there. What else is wrong with it? They can't sell or mortgage the property unless all of the heirs agree. What does that mean? How do you sell property? You have to have a clear title, a deed that says you own it, therefore you are allowed to sell it. When that deed does not exist, the property cannot be sold. It can't be mortgaged. For instance, you can't get a second mortgage on it or an equity line on the property because you are not entitled to do so when the title is entitled to do so when the deed title is splintered.
it kind of goes without saying, but you only have the level of interest, you only can give away what you have, right? So if you have 40 people, even though someone wants to deal with you and give you that mortgage or whatever, if you can only give your piece. So when people have all these people that are unidentified and the title's a little murky, that's when the people are trying to get security, mortgages, they want to get security on this land. But if they can't feel secure that you can show them that every single piece is accounted for, then that's when they deny you mortgages, they deny you some of these loans, because they're saying, we don't know for sure that we're going to be protected. If it's one person, we know that you have 100% interest, we can deal with you, get that mortgage on that property. But if you have, heirs, and it's not sure, they're not sure who's fully owning, and there's no trail, they're not going to do it.
Right, right. I want to kind of go back to the question about the taxes and how, because this kind of goes in line with that same thing, that no one can sell it, no one can mortgage it, other than your, 1/20th portion. Like Keith was saying, you can only sell what you have. And more likely than not, nobody's going to buy a 1/20th portion unless they think down the line they're going to get those other 19/20ths. Right. And so a lot of times what ends up happening is nobody pays those taxes, right? Well, if I'm paying the taxes and then they stop because they don't have a right to any more of it, and then no one pays it. And then what happens? The property is taken over by the county or the state, depending on what jurisdiction you're in, and sold for a tax lien. And so, that's really, really unfortunate when you could have acres and acres and acres of property that nobody's paying the taxes on, and so you still lose it. So resolving those communication failures and those communication gaps and those misunderstandings as to who has what right certainly could alleviate some of the issues that come into play with heirs property. Let's talk about the one where you can't participate in government programs like USDA or HUD or FEMA. So FEMA is the big one that I want to concentrate on. When I see that one, every time I go back to Hurricane Katrina and all of that land and property that was destroyed, and a lot of it was heirs property. That's why to this day, it is still sitting like it was when people did cleanup efforts, because nobody knew who owned that little bit of property in the middle of wherever it was. And so they weren't eligible for the government programs that would have helped clean up or would have helped rebuild the property. I also think about a situation that cropped up in a building that I once worked in. And there was a parking lot attached to the building. And this parking lot had maybe room for about 400 vehicles. And there were 20, 30 owners of this plot of land where they built the parking lot. Well, 2 of those owners would not sell. They just would not. And their plots just happened to be not in the very middle, but kind of off center. And so they built this entire parking lot around them. There was like 4 trees sitting there around concrete. And that was what the issue was. Those people that owned that portion of the land wouldn't sell. So they just built all around them. Well, then that landlocked them. Eventually they had to give up their portion. But, things like that, it ends up splintering families. It ends up splintering relationships. That was a corporate entity, the group of people that own that entity. And, one of them, it's my understanding, one of them went to his grave saying, I don't ever want to give up that little piece of property. I don't care if there's a parking lot around it or not. He was not giving it up. And what that does is it makes sometimes otherwise very rational people irrational. And otherwise harmonious people, they get into disagreements and you cannot repair that. So not only is the land lost, but the relationship is forever splintered as well. So those are some of the things that are really, really tragically wrong with the creation of heirs property. The other part I just want to concentrate on before we move on is the homestead exemption. Tax time, if you own property and you live on that property, you are entitled to a tax break, an exemption on your taxes. That's a reduction in the property taxes. However, if you are a 1/20th owner or fractional owner and you don't live on that property, well, that means, and maybe nobody lives on it, then nobody's getting that homestead exemption for that property. So again, that's a negative in the creation and continued existence of heirs property.
I like what you told with that story, Shannon, about the guy who went to his grave and said, "I'm just keeping his property." And I think a lot of times families make mistakes that the next generation feels as strongly about that land as the other generation did, right? So he went to his grave saying, "I'm going to keep this property," but his grandson might have been like, when grandpa dies, I'm going to get this piece, cash out, and then go do something. So, a lot of times that's what happens when it goes to the next generation. If that family history and that community is not as strong and that pull to and tie to the land isn't there, that's when you have someone selling off a piece or trying to sell something that a prior generation figured they would never do.
Right. Right. Instead of planning for generational wealth, he could have sold that property when he had the opportunity and sent grandchildren and great-grandchildren and, great-great-grandchildren to college on what he made on that or the investment that came from that. Instead, they're sitting there with a 12 by 12 portion of property that nobody can do anything with. And so, it helps to have the lines of communication open, even if it's generational lines. I've had people come to my office where grandma has passed away, leaving, 3 children. And one of those people's children comes to my office as the grandchild. Auntie and uncle don't want to give it up, but her father is the one paying the taxes. Well, auntie and uncle don't have to give it up. They all have the same right to the property, especially when somebody doesn't engage in that strategic estate planning we talked about. So what does that look like when it comes to planning your estate, and how can it be alleviated, or how is it further created? And these next couple of tidbits of information that we're going to share with you are quite legal. There's a lot of legal language in there, and so you may end up with more questions. I'm going to start off talking about adverse possession because I know that we did not further discuss this further on in the slideshow. So adverse possession is probably a right to property that many of you have probably heard of. This is what some people call squatters' rights. Right. And this is where a person or somebody has taken ownership of the property just by nature of the fact that they are there, and nobody, the true owners, haven't said anything about it. They knew that they were there. It was open and obvious to everyone around, but they never went through the legal process of having the title to that property put in their name. They are a squatter. They're there, they're using the property without legal authority. In every jurisdiction, every state has a different definition of how long that person can be there before they take that property as their own. Some places it's 6 years, some people it's 7 years. It depends on the jurisdiction. And so if they reach that, whatever the year mark is or the time frame mark is, and nobody has challenged their right to be there, and there's legal words, it has to be open and it has to be obvious to everyone else, then they are entitled to say, now the property is mine, and they go through the legal process of having their name put on the title. That's what adverse possession is. It's acquiring title as a squatter.
And also with and this brings me back, bad property class memories for all anyone who.
Yeah, I'm twitching.
But we have a picture of those rolling hills and this vast area. And when you're talking about deeds, the deed will have a boundary line in the description saying from this here, from this, and it kind of gives the outline of the property, which if you just stand outside in the air and look around, you don't know exactly where your land ends. Right? So what happens sometimes is the neighbor might put a fence up or some kind of structure, and you're just not aware that that's even part of your property. So adverse possession is kind of a legal mechanism where if that structure or that fence has been there, like Shannon says, 6-7 years, and then you get a survey done, you're like, oh, hey, Mr. Jones is actually on our property, and then they say, hey, the court's like, well, it's been there, 6-7 years, you didn't say anything, so now it's his. So that's what adverse possession is. So you can imagine in what we're talking about in our scenario where this property gets passed down and people aren't really paying attention or don't really know the boundaries, this can happen very easily because you don't know exactly, if you're doing a little small subdivision in the suburbs, you know pretty much where you begin and end. But if you're out there with 190 acres and you don't know exactly where that begins and ends, or what's the edge of your property.
Yeah. Or say the property has been sitting there abandoned and somebody puts a trailer on the lot in the back portion of the lot where it's away from anyone else, but it is on that property, actually sitting on that property, right? And maybe there's some neighboring property owners, they see the trailer, they don't ask, they think somebody's living there. Oh, great, I'm glad somebody's finally on that property, but they don't know who the actual owners are to notify them. Right? And actual owners never go check on it because there's 30 of them and nobody knows that they need to go check on it. Well, that person has just shimmied their way into property ownership if that goes on for so long. So what happens when heir property is created? There's too many owners on the deed or the title is not clear. What that does is it diminishes that family's ability to do anything that would help them create generational wealth. For instance, now without that clear title, they cannot pass that property on to their children. Right?
And they can't sell it for a profit because either your piece is so small that you can verify that no one wants to sell, it's not marketable, or you can't even figure out what you own in order to package it together to sell it all. So that's when we might have to go through these partition actions and other things that we'll talk about later. And so you're not going to get a profit that would be the fair market value. You'll get some money, but it's not what you should have gotten. So that's another part of this is you may get something, but it's not nearly what it should have been if you had everything in order.
Right. You also can't generate any income from the natural resources on the property or from, for instance, say there's lumber. Well, let's talk about that right now. The price of lumber has skyrocketed. I think I saw earlier today that it was 108% in the last couple of months. So imagine having a property that has a whole lot of trees on it. Right now in today's economy and everything that's going on, somebody would want to sell those trees for the lumber, for the profit. But you can't do that without clear title to saying, yes, you own those trees, therefore you can sell the lumber.
And generating income from renting, leasing the property. If I'm going to lease it, it goes back to that same theory. I can only lease what I control, what I have, I can prove that I control. If I don't know if I have that property, I can't go out and create a lease and feel comfortable that I can collect that rent because I'm not sure if I have that right in that property, or certainly can't prove it in other things, collateral, line of credit, mortgage, all those things, some security is required, and you don't have that security if your title is not clear.
Right. And all of those things that we just listed are what can be used to create generational wealth. Without that property, you can't do any of these things. And therefore, your ability to create generational wealth with that property being the tool or the mechanism to do so is diminished. How does that impact our communities? Well, our properties are attached to people that are attached to the community. If you look at it like a circle, you start with the individual, that goes out to the family, that goes out to the community, that goes out to the state, that goes out, it just continues to go. And when you start with that individual and they lose that property, well, it cannot trickle up or out from there. And when we lose that, we lose access to federal or state funding for improvement. Kind of talked about that when we were talking about the government benefits that you could potentially be entitled to that you lose. It also hinders our ways of having affordable housing and family stability. When, you know, cousin so-and-so was living in grandma's house and cousin so-and-so had a roof over his head and everything was fine, and this, you know, raised his family in that house. And then what happened? He passed away, leaving the property without ownership. The family splinters. And, you know, his children, kind of like Keith was saying earlier, his children may not have wanted it or to continue to live in that or to maintain the property in the family, but maybe that grandchild had a connection to it. Or maybe that grandchild was thinking more big picture. Oh, I'm going to turn this into a such and such when I get the property. But it doesn't happen like that when people, again, don't engage in that strategic planning to allow that to happen.
And decreases owner-occupied homes and family-owned farms. I know I was thinking, you know, I came from New York. If you don't know my background, I came from New York, came down to Georgia. And a lot of us, you know, if you're from Georgia, you know, we got a lot of Northerners who realize that it's a lot cheaper to live down here. But if you also had the ability to get, say, free housing, so to speak, if they have family-owned housing, I can stay in the family house. I don't need to pay rent or mortgage in some other place. That helps generational wealth, right? I don't have to pay $1,600, $2,000 a month for a mortgage because I can stay on the family property. Now I can build up wealth for the family, and then if we at some point in time decide to sell it, then that's more wealth for the family. But those actions are you know, blocked if I can't get on this property or I can't turn this profit on this property. So we lose a lot of generational wealth in just the ripple effect of not only that current generation, but just on and on and on of all the things that could have been done, but are not being able just because just the paperwork is not done.
Yeah. And along with that, the order and the paperwork, let's talk about if something is going on the property and it is a violation of a code. And the code enforcement officers or office, they don't know who to contact to see that it stops, or to see that it's brought up to code or the regulations are met. Therefore, it just sits unkept. Like, for instance, say the code says that you can't have trash. You can't have trash or tires. I'm going to use that one because I saw this example recently on the news. You can't have tires or trash on the property that is visible from the road. All right, well, there was a community here in Metro Atlanta where somebody was using a bit of property as a dumping ground. And one thing that was continuously dumped on this piece of property were tires. And tires are rubber. And when it rains, all the water was, you know, in the tire itself. And so then the land became mosquito infested. And the neighbors were like, we cannot get rid of the mosquitoes. It's horrible. And not to mention that there were some of them that were complaining about the smell because they had turned this piece of property. Nobody knew who owned it. Nobody could enforce it because of that. They had turned it into a veritable dumping ground. And so what that does is that diminishes our neighboring property values. And when the property values of our neighbors are diminished, then that trickles out to the entire community. So, and again, when you have a community where the property values are low, there goes our generational wealth again. Let's talk a little bit about quiet title. I already covered adverse possession. Let's talk about quiet title. And title, again, is the deed, the piece of paper that says who owns the property. And anytime you want to purchase a plot of land or a piece of property, there you have to have what's called a title search. And the records will go back to when that property was first put into place, and the land markers, like Keith was talking about, the zone and the land description and the lines, the property lines, when they are set, that identifies that piece of property. So title search will go all the way back to when that first was created, who bought it, and then who bought it from them, and then who bought it from them, and who bought it from them, and who bought it from them. And oh, here, nobody was able to buy it because the person's name on the deed now is deceased, and that person didn't have a will, and they had 4 children who had 8 children, and 2 of those children were deceased, and 4 of the grandchildren are adults now. And it just, now you have to look at all of those things. And without clearing up all of those things, you will not have clear title. All right, you can search through years and years of records, and it may not accurately show what the original intent of that property was, because verbal agreements don't matter. If grandma said, oh baby, when I go, I'll make sure that you get the keys to my house, this is yours. Okay, but if that was never reduced to writing, and oh, by the way, that writing was never recorded with the land records office, then what grandma said may not ever come to fruition. And so you can't get clear title based on what I heard. You can't get clear title based on, well, that's what grandma told me. And, my brother can verify that, and that it doesn't work like that. You have to have the piece of paper that imitates that verbal chain of instruction. And you have to have the piece of paper that dictates who owns the property. That verbal information does not matter at all.
Yes, see, we didn't say this at the beginning. Shannon and I are estate planning attorneys, not real estate attorneys, because if you're not a lawyer, you don't necessarily realize the distinction between some of the practice areas. But in our field, we are so used to hearing people tell us what someone else told them, and we're saying, okay, but that person's deceased. There's no record. There's no way to prove it. So, we're operating, especially with the kind of topic we're talking about with generation of things passing down. You don't have the ability to go back to ask the person what they wanted to happen. So now you fall back on, okay, what does the state statute say? The state statute says this is where it goes. So that it happens, even if it doesn't happen in literal practice, it happens by operation of law. So I could own air property right now. In my family's from South Carolina, I probably have air property there that I'm not aware of. Okay, you don't have to know that you have air property. It's by operation of law. Like Shannon said, someone starts going through the marketable title search, and then they see that someone was there. Okay, oh, his mom had a son. Okay, he's now the heir. But that's all operation of law. But if these things are not recorded and written down, then you're falling back on a system that is not going to be flexible and does not care what your intent was. It's just order. I just want things to be done so I can get the taxes, I can get some title, I can do whatever. They do not care about the history of the property and what the people really want to happen.
Right, right. And when Keith just said it has to be in order and written down, that means it has to be written on a legal document called a deed, and it has to actually be recorded at the records office, whatever that county records office is. Here in Georgia, each county has their records division, the property division, and depends on what jurisdiction you're in, what they call it, but that's where it has to be recorded. Otherwise, it does not matter. If they wrote it down on a piece of paper standing in the barn one day and said, here, sign here, you sign here, doesn't matter if it was 1, never recorded, and 2, it has to be recorded on the piece of paper so that the records office knows that's what it is. All right, so clear title, we were just talking about what that means. Clear title and marketable title are two different things. All right, clear title is basically marketable title plus the exclusive right to possess the property. And what is marketable title? That means it is reasonably free from doubt as to who owns it. All right, so it's easier to get marketable title once you have a deed and maybe there's not a whole lot of heirs. Like grandma owned it, she had one child who had one child, and that one child is the only person still living. Okay, no, no marriages, wills were in place. We can look at that and say, you know what, there's really not much doubt as to who owned this. It has to be this third person here, right? Even if the deed does not say that. So how do we get that deed? Then we have to go through, consolidate it, clear up the title. We can't have any deceased person's name on it. That is not clear title, right? So you clear all those things up. You have to do that though through probating estates, whether the person died with a will or without a will. Here in Georgia, it's a little bit different where you can not write a will here and say, I leave my property to so-and-so and attach a deed to it. Many states have what's called a transfer on death deed, or they call it a ladybird deed. That different states call it different things, where you can transfer property through a deed at death attached to your will. We don't have that here in Georgia. So there are ways you have to go through the proper channels to transfer. And when those are not done, then you have to probate the estate. Anyone who passes away with or without a will leaving property, they have to go through the process of the court permission to transfer that property. And so you obtain clear marketable title by consolidating title so that there's only one heir that owns it, or one company, or it's in a trust, or you probate the estate of any and all deceased property owners, or you go through a voluntary partition agreement. That means if there are 20 people that own the property, they voluntarily split that property up into their 20, each of their 1/20th portions, or some other partition or splitting of the property.
Good luck getting 20 people to agree on anything.
Right. It's hard getting even 2 people. Another way of partitioning, or a statutory partition process, is this Uniform Partition of Heirs Property Act. And this is probably the one that people on this call have either been through personally, or have heard about it happening to someone in their family or in history, or read something about it on the news recently. It's been everywhere. If any of you got on the ICABA World page in the last 2 weeks, I posted 2 articles about this happening. One was just a nationwide where it's happening, and one was specific to South Carolina lineage. So the Uniform Partition of Heirs Property Act basically is a law that says how property can be partitioned or split off if it occurs. All 4 of these have to be present in order for the uniform law to occur or to kick into action. The first thing, the property has to be titled as tenancy in common. That's what Keith was talking about earlier. Tenancy in common means there is not a deed or anything that says they own it as joint tenants with rights of survivorship, meaning, we 2 people own it, and when one person passes away, the other one has a right to it. And then after that person passes away, if they haven't done anything, then it becomes heir property. But that's what the joint tenants is. So they have to own it as tenants in common. Also, at least one of those co-tenants has acquired that title, their co-tenancy, from a relative. All right, relative. You want to take the last 2, Keith?
Yeah, and then Also, the relative piece is just to make sure also that it's not just a strictly business transaction, right? So it's not just, they're not worried about someone who acquired property in some commercial way. That this is the inheritance transaction. So the third part is we want to at least make sure it's 20% interest is traceable to a family member. We don't want some you know, I have 1/100th and then I'm going to start this action. You know, so you have to have at least 20% traceable to a family member, and then without a written agreement. So if you have a written agreement in place, there's no need for us to bring this act into place because everyone already agreed on what they were going to do. So basically, you know, this is designed for those situations. Shannon mentioned she posted something just high level. When you have all these splintered interests, all it takes is that one person to sell to someone, like a speculator, and that speculator is like, okay, I got my hands on one little piece of this property, and now I'm going to force a sale, and that forced sale was getting returns that were far less than the family would have gotten had they held on and gotten regular market value. And first of all, the family probably wanted to hold on to it, but they couldn't because the court went through the action of selling it. So this act is trying to say, let's counteract those situations and say, in those particular situations where we can, we're going to give some remedy, some procedures that protect those family members that actually want to keep the property in the family's hands or remain co-tenants. So we're going to walk through what some of those things are. And this also, we'll talk about the procedure. This talks about when it gives the states that are part of this an incentive that they have priority for certain federal loans. So we mentioned how it's so hard to, when you don't have clear title, to get some of these loans. And so now Congress said, look, if you to the states, if you can get this, you know, mess basically organized with this act and put it where we can have some procedure, we'll give you priority on getting some federal loans.
Right. And what you can do with those federal loans, again, you can build generational wealth. Maybe the property is excellent farmland. There's the 2018 Farm Bill. Or the property has some natural resource on it that can be used. But you can't excavate it because you don't have, you know, money to do so. You can get a loan to do that, but it's only reserved for these properties that meet those 4 criteria that we mentioned, because they want to maintain it in the family for as long as possible, in order to honor, for lack of a better term, those deceased relatives who had the clear title. They had it originally, but, you know, lack of planning on their part is where it started to splinter. So this Uniform Act is in place in order to help, basically. And essentially, there's nothing in it that prevents a willing buyer and a willing seller. So, you know, person X comes in, they want to buy this property. There's nothing that prevents them from transferring that ownership, from selling their part. All right. What it does, though, is it says, you know, all co-tenants of it, unless they have something in writing saying it, then we're going to step in and help. What does all of that mean? This is probably where many of you have come to. This is an excellent example of what that means. That means if even one single heir person right here says, yes, I want to sell, and all of these are saying no, if this one person says, yes, I want to sell, and a buyer comes in and they have met those 4 criteria, you know, they acquired the land from a relative and 20% of them owned it from a relative, all of those 4 criteria that we previously talked about, if they are met, they want to sell, that can trigger a partition sale. All right. What that means is now this property, the whole lot of it, not just that one person's part, the whole thing of it can be sold at an auction. All right. Just like you go to, they have these shows on now. What's the one called where Storage Wars, where people go and they buy up an entire storage unit not knowing what the contents of the storage unit are. They just know that that unit hasn't been paid for. It is kind of the same thing. They have this auction where they sell that part of land, that entire plot of land, because one person has said they want to sell. All right. What that does is it results in the entire property being sold at an auction. How does that auction occur? They have to put notice in the newspaper or notice wherever notices of such actions would occur. Okay. Now imagine that that would be the newspaper, the local newspaper, and 40 of the 80 people don't live there locally, and the rest of them don't ever get the newspaper. Will they ever know about that auction coming up to keep the property in the family? No, they will never know about it. Is it legal? Yes, it's legal. Is it highly unfair when it happens? Yes, it feels very, very, very unfair when it happens, because now you thought maybe you had an ownership right in this property, or maybe you were even the one paying the property taxes, whatever it is, and now you've lost the property at an auction. It's very tragic, but it can happen. All right, what is a way to avoid it happening, and how do we get around it? Well, there's this thing called probate. Probate court. And probate is the legal process, or the court, right? Because the process is handled by the probate court in most jurisdictions, that you have to go through in order to properly distribute the assets from a person when they pass away.
And the thing with that people don't realize with probate, they know the part about doing the distribution to the family, but they don't realize that the process is organized first to pay the creditors. So this whole process, when you have land going through probate, you also have to remember this is going to be exposed to potential, debts that that person had in life. So there may be a risk also to this land going through this process of they pass away with medical bills, or owe some IRS stuff, or just have judgments against them, or whatever. That land is potentially subject to that. Now, presuming that it passes through that, or things can be paid and the land can actually go to the family, that's when you have the issues of, okay, who gets it at that point? Does it go by someone's will, where they said that they wanted to go someplace in particular and they wrote it down and had the document follow the formal standards? Or did they not have a document and then they're called intestate, and then the state says, okay, we don't know what they really would have wanted, so we're going to substitute our state judgment, assuming, well, based on whoever's alive, surely they would want the surviving spouse to have something, surely they want the kids to have something. May not actually be what the person wanted, but we're going to assume that because that's what the statute says. So probate is a way to get some more order for the process for the creditors, and then to help the family get the property. But you can take control of this process by as Sandra mentioned, way back in the beginning, having that strategic planning. If you want to, you could avoid this whole process if you want, by taking certain steps. But if you don't, you can still have a will that still says where you want things to go and makes it a little easier to handle.
Yeah, I want to talk about the creditors just briefly. Creditors, predators, they're all one and the same. It doesn't have to be Visa, MasterCard, American Express. A creditor can be a family member, and that family member turns into a predator when somebody dies without a will in place or without properly distributing that property. If they think you owe them and they're going to get their payback from that property, they will go after it. And probate is a public process. I can't say that. It is a public process. So anytime anyone passes away and their estate goes through the probate process, now it's opened up for everyone to see what they have or don't have, right? The nosy Nelly neighbors and everyone else can now see it. And so there are ways to eliminate that partially, or in some cases fully. I'm going to go share some of these examples, and I do want to give credit to the Georgia Heirs Property Law Center. Fantastic, phenomenal resource for anyone that has any sort of heir property issues. They all day, every day live in this quagmire in the weeds of what heir property is. So I did take some of their examples and I'm going to share them with you just so you can see what we're talking about and what in real life this really can look like. So in this example, grandma owns a home and she dies without a will. We'll say grandma's name was the only name on that deed. All right, even though she was married to grandpa, her name was on the deed. She owned a home, she dies without a will. That means she dies intestate. She's survived by her husband and 6 children. So now that property, since she passed away without a will, her name is the only one on the deed. Now there are 7 people who have an equal right to that property. It's co-owned, tenants in common by all 7 of these people. So that goes back to one of those beginning slides where we said each of them are entitled to X and each of them are entitled to Y. Each of these 7 people are entitled to each of those things, to everything when it comes to the property. Next example. You want to handle this one, Keith?
Yeah, so grandma again, she passes away. She has 6 children, but 2 of the children passed away and they each had 3 children. So now we had, instead of just grandpa and the 6 children, we have grandpa, the 4 remaining children, and then now 6 grandchildren. So we now have 11 people who are now heirs to this property and have an undivided interest in it. Even though they have a fractional interest in it, they have an undivided interest in the property. So if one of them, if we say grandson Alvin under Amy, grandson Alvin doesn't want that property, even though everybody else wants it, Alvin, that grandkid can start a petition action and cause some problems or get that property sold. Or Alvin can try to cash out and give it to a speculator. So now you have a speculator and 10 family members, and the speculator tries to get the property sold. So you can see the more you start adding people, you're creating more and more opportunities for someone to go astray or someone to lose that interest.
Yeah. So how do we prevent this? Through estate planning. And there are options. We all like options. There are options in order to prevent heir property from occurring. 2 options while you are living. The first is you create a joint tenancy with right of survivorship. The only downfall to that one is once the last person listed on that deed with the survivorship rights passes away, if they don't plan their estate, now potentially heir property is created. But during your lifetime, that is one way to prevent heir property, is to set the property up as joint tenancy with rights of survivorship. The second way to create an estate plan that prevents heir property while you're living is to place the property in an LLC or in a trust. Now, there are 2 things. They are potential negative ways of doing it. However, it still works. So if you put it in an LLC, a limited liability company, then the LLC owns the property. Well, then you have to take into consideration, and this is the only thing that you have to now look at, is who's controlling that LLC? Who are the members? And so if that's family, well, then maybe one person has the rights in it, they're controlling, and so they may be the decision-making authority. And also, all heirs have to agree to transfer their individual interests into that LLC potentially. So during your lifetime, you can do that. Putting it in a trust, now that allows you to move it into the property into the trust. The trust dictates what happens to the property from here on out. Therefore, potentially, rather than creating heir property, you're creating generational wealth, because now the trust can dictate what happens with that property for 2, 3, 10 generations from now. Also, I'm backing up a little bit. If you put it in an LLC, then they lose that homestead exemption. If you put it in a trust and somebody is still living in it, then they continue to have that homestead exemption.
With the LLC, it has an operating agreement, and that allows you to have some kind of provisions on like right of first refusal, so you can prevent that person from going outside and selling to an outside investor or someone outside the family, because they have to offer it to the other investors first. So there's a lot of things you can do with the LLC that can help keep that property together. And the trust, like Shannon says, that can go generation to generation. The beautiful part of trust, if you're familiar with them, they don't pass through probate. So all that process of being exposed to creditors and dealing with the court, you don't need to deal with that. So you put that property in there, and then you avoid that probate process at each generation. And also, if you do it early enough, you can do some tax planning that allows that trust to keep growing without some estate taxes at each generation. So you can really create what's called a dynasty trust and really do generational, true generational planning of great-grandchildren, the great-great-grands, and all that, and keep it in that entity for everyone to benefit from, but the trustee manages it there.
Right, right. So that is one strategic estate planning way and option of preventing heir property. The second one is to have the property properly transferred upon death. And there are three main ways you can properly transfer property at death to prevent heir property from occurring. The first one is you just bequest it or leave it to, or will it to a single beneficiary. All right, the same thing though with that, once that single beneficiary passes away, if they haven't properly planned their estate, then heir property is created all over again. But you haven't done it at your end upon death.
Yeah, the executor could sell the property and just distribute the proceeds. Of course, everyone gets the value from the land, but of course, if the intent of the ancestor was to actually keep the land and have them actually use the land, that defeats that particular purpose. But it's probably better than having that sale that happens where well, if you lose it all together, certainly better than that, or if you just recoup only a fraction at a forced sale at a pennies on the dollar. So there is a trade-off there. And of course, the other option, executor divides property between the beneficiaries. So maybe if you had that formal process with probate, and you can have an executor actually divide that property up where people don't have to own it together, and then you have little interest where everyone's 100%, then they can go take their piece and then have their own ownership in it. So, but all this stuff you have to really think through. How do you, what's the most important thing to you? If the most important thing is to have the land, and you don't have that executor sell the property. But the most, you probably want to build the most flexibility in, even though some people feel very strongly about, I want this land to be in the family, but families change, times change, people move away. You might have grown up in Louisiana, now you live in Chicago. Do you really want to have this land that you're trying to take care of? Maybe you do want to just sell it and have everyone get their share and move forward. So there are a lot of things to talk about. And Shannon and I had, if you go back, we had a two-part family meeting webinar, where we need to have these conversations amongst the family. Like, what do we really want to happen with all this stuff long term? Because a lot of times people don't talk enough and express what they really want to happen. And if these conversations come up, probably a lot of these issues could go away.
Right, right. So, any questions? I want to see if we have any questions. I see that there's one in the chat window. Let me open that one up. Let's see here.
Yeah, that was a question. You just said good information.
Oh, good information. Thank you. Thank you all. Any questions? We are certainly here to answer any questions that you have. We're also going to share our contact information. Feel free to reach out to Keith or myself if you have questions related to the heir property information or to any of our other estate planning topics that we've covered. Again, any questions before we wrap up? I want to say thank you to ICABA World Community again for allowing platforms such as this to disseminate information. We always know that we just sometimes don't know what we don't know, but we do know that we do better when we know better. And so this is Keith and I's way of ensuring or helping people to know better so that we can do better.
Please join us in looking at ICABA World, as Shannon mentioned, but also look at the overall organization. I know it's COVID and we don't really get the chance to gather right now, but hopefully in the future we'll get a chance. And this organization is really excellent for bringing together a lot of Black professionals and owners, and just creating a lot of place for networking to happen. So we are part of the Atlanta chapter in their advisory board, but you know, this in Florida they have strong membership, and I think they're trying to grow for the rest of the country. So if you're interested, go to the website ICABA, and then of course join our group, hopefully in ICABA World, and continue the conversation.
That's right. Thanks everybody. Have a great evening.
Good night. Thank you for joining.